Okay, good morning. It is April 15th. We're taking back up page 578. And we have Erica Holm here. So if you'd like to introduce yourself, the floor is all yours.
Thanks. Thank you for having me. Thank you for taking up this bill and putting so much time and energy and effort into it. My name is Erica Holm. I am here to provide testimony identified as a co-executive director for Central Vermont Humane Society. But I did want to also mention that I am the chair for the Animal Cruelty Investigation Advisory Board, which is a board that was created by the legislature in 2015 by statute. And so we have been created to review, assess, examine all aspects of animal cruelty investigations and animal welfare in our state. And so the board is made up of many different folks from different agencies. So we have representation from the Department of Ag, the Public Safety Department, the Sheriff's Association, state's attorneys. We have private veterinarians, two representatives from humane societies or animal welfare organizations, the Dog Club of Vermont, and so on. So lots of various organizations that are involved in animal cruelty, whether on an investigative level or just providing good animal welfare. So I did submit a letter on behalf of the board late last night. Sorry for my delay, just saying we are in support, our board is in support of this bill. So I can also answer any questions that you think maybe could be answered by the board and our stand on it. From the Humane Society perspective, we absolutely support the bill. There's aspects of it I don't need to spend much time talking about, such as the bestiality laws, which were a long time coming. And so there's certainly nothing that we see wrong with increasing the penalties and making aspects of that a felony. More importantly, what I want to touch on are the two sections that really do deal with seizures and then the civil forfeiture process. Many years ago, shelters were able to help a little more in terms of law enforcement needing places for animals to go when they were seized. Seizures were also rare. I think surrender was worked on a lot more. And I know that.
Can I just ask,
Yeah.
the distinction being surrender, you get the animal back, and seizure, they're confiscated?
So seizure is confiscated and held through the process of either civil forfeiture or criminal charges. A surrender is when the person who has the animals and is mistreating them agrees to surrender them to, like, Central Vermont Humane Society. So, for example, back in 2015, there was a case in Eden with 90 dogs.
Right.
And we spent an entire day there removing the animals, being examined by vets and determining, yes, this one's bad enough, can be seized, but spent the entire day really talking through with the person and convincing her to surrender. So we took a large portion of the animals out that day, surrendered to us, which meant that we could disperse them to other humane societies, get them the medical care that they needed right away, and get them into home.
And so just to clarify, so surrender means you surrender title?
Correct.
Great.
The owner of the animal is surrendering title to whatever agency is taking, and it could be the state who might be there without a supporting agency, and then they can turn it over to an adoption agency to work further on it. That was also prior to there being a civil forfeiture process. So one of the reasons everybody worked so hard for it not to be a seizure is because you could wait years while it went through the criminal process. And I think Lisa Mylott mentioned the Franklin County. Yeah, so the Franklin County Animal Rescue that had 7 or 8 dogs that were held for well over a year and bankrupted that organization. So humane societies have been more and more hesitant to help in seizure cases because even though there is a civil forfeiture process that's relatively new, it still is not timely. And so taking in, more than one or two dogs in a seizure case can tie up your facility in ways that cripple you. And it's also not healthy for the animals to be left there indefinitely. So having a civil forfeiture process is definitely better than what it was with waiting for the criminal process that can be delayed and delayed and delayed. So, but it's still too long. I know Lisa mentioned to you folks last Friday about the horses out of Townsend, and that they were seized last June or July, and they're still waiting for the final ruling from the judge. And that's the third seizure out of that one location, and the other two were, given ownership to the state. So especially with horses, a place to keep them and then care for them and feed them and bring them back to health is really, really cumbersome. It's difficult enough for those of us that manage and handle dogs. And especially the climate right now with the housing crisis that we have going on in Vermont, and especially fewer housing places are allowing pets. So there are people who are losing their current housing and having much more difficulty finding housing that will let them bring their pet with them. Excuse me. So we're seeing a lot more surrenders of animals that have been in a home 5, 6, 7 years, are truly part of that family, and they can't find somewhere to live with their pet. And so we have been managing our surrender appointments as best we can, triaging them for, okay, you waited till the last minute and now you're just about homeless. So we're going to take that in over somebody that says, I have to move out in 30 days. We'll schedule that appointment out further. Having our kennels taken up by animals that we do not own yet. We don't know if we're going to get them in a civil forfeiture case, but we are feeding them, caring for them, exercising them. They take up staff time, volunteer time, medical care in many cases, because of course, often if they're taken in a cruelty case, they need medical care. So there's lots of work and time and effort that goes into that. Plus, even on the administrative side, obviously, we're keeping very specific records for those animals, slightly different from what we care for in our normal day-to-day operations, because of having to go through a court case for them. So we do support tightening up these timelines as much as possible. I don't want to take away judges' ability to have discretion, obviously, in their cases and their rulings, but giving them the ability to just extend this out indefinitely is going to mean that fewer humane societies will step up and help. And the state has nowhere to send animals right now. The goal is that eventually the state has facilities in some form that can help take in animals as needed. We also feel that as cases happen and they're adjudicated in favor of animals being taken away, we will see a decrease in animal cruelty cases because people are going to understand there's a consequence for their actions of mistreating animals, and that they will do stuff, or they'll be more likely at least to surrender quickly rather than fighting through a seizure process. I work with law enforcement officers now when they're going to go on a case and talking with them about ways they can negotiate a surrender without trading away criminal charges, right? We don't want to say, well, if you surrender the animals, we won't charge you with these heinous crimes. We want them to be charged if they are committing animal cruelty under our statutes, but we also, we don't want them using the animals as leverage if possible. So it has to negotiate both. Surrender is in your best interest, especially financially. And so hopefully we'll see that go down as these things are working through. So that's sort of the timeline part of it. I know, also have brought up the issue of, tack order or nail and mail. And I just wanted to point out for the cases that I have been involved in regarding seizing animals, if the owner or offender was not on site, the expectation is they should be coming back to care for that animal within a certain amount of time. So if they aren't coming back to feed, provide water, in a timely manner to see that tack order, then that in itself is committing a violation of our statute. Okay? If they aren't giving them food or water within 24 hours, then that alone violated it. So my expectation is that if that tack order is there, they're going to see that in a very reasonable amount of time. And if they don't, then the animal's suffering even more. And a current case, you know, the only water that was there was frozen solid, buckets this tall, frozen solid, not just a little film of ice on the top. So that owner may not have been coming there daily. And if he was not swapping out the water. But still the expectation is he should be there, providing them food and water and seeing that order. So, I would love for you folks to, approve a way that we can, certainly be, aware of and respect people's, property rights, but recognize that, these are living sentient beings. It's not somebody's couch or TV that's being taken away from them. So those are the biggest points I wanted to touch on. Did you have any questions for me? Yeah.
I'm wondering about, you mentioned that one agency went out of business, because its facilities were filled with animals that they didn't have title to. I'm wondering about the security post. You can post security, and this is page 18 of the bill.
I think I have a different version of what you guys have. I'm well aware of that. Yeah.
I'll describe
Yeah.
what I'm asking. So on page 19, it says, the court shall hold a forfeiture hearing if a request is made within 14 days after the seizure by a person claiming a legal interest in the animal at the time of seizure. And I believe 14 days is a shorter window than currently exists.
Well, and that's also an automatic trigger. The owner has to request the hearing, which is a wonderful change. Yes.
And then it says, if the defendant has requested that the security be reduced or waived on the basis of financial hardship, I'm just wondering how common it would be for someone whose animals are seized, that they would be in financial hardship, and that therefore this period, because that if they claim financial hardship, then a hearing has to be held within 30 days, and the 30-day period can be extended for good cause shown. So suddenly you're at what,
So you
74 days, if there's a hearing requested, and then it's delayed another 30 days. So I'm wondering how often would people who are having their animals seized be in financial hardship in your experience?
I would imagine they're going to claim that on every single case.
That's kind of where I was going.
Whether that's accurate or not, I don't know. And it, if a judge chooses to waive it, that's certainly their prerogative. Right now, there is no bond, security deposit, nothing is held. And so the organizations that have the animals are, paying all these costs. And, frankly, if the animal is, if the owner loses, then they supposedly owe us the money, right, for our care. I'd rather they surrender and we cover all these costs, right, than to drag this out any further. I would assume they're going to generally say a financial hardship. I think what the Department of Animal Welfare is planning for to create a cost inventory it's not a lot of money, and this person should be putting that into their animals anyway, right? So to say they can't afford a certain amount per animal per day to be paid to the organization that's feeding and caring for them, is probably a little disingenuous, but they may be able to argue, well, I already
Right.
bought, a year's worth of food. I was planning on feeding that out or whatever, their argument might be.
Yeah, I guess I'm just wondering, if the whole point is to reduce the amount of time that, humanitarian agencies have to feed and shelter the animals. And, put their own organizations at risk in doing so.
Right.
This is the one moment where it seems to me suddenly the timeline can stretch out to 2.5 months.
I mean, that is a moment. There is no real, like they can extend it for a good cause. So
Yeah.
to find that, and to be clear, having to feed a dog for an extra 30 days is not going to bankrupt any organization. What the issue is that you fill up the kennels with seized animals that we now cannot continue to provide the service to our community that we've been providing, right? So we're an adoption center, a boarding facility that I want some animal offender to, pay boarding fees. We want to help animals in the community, get them into, good homes. And so even though like our adoption fees don't cover all of our costs that way, we're a 501c3 that we fund ourselves with fundraising. But it's really difficult to fundraise when you might have your kennels filled with animals that you don't own and you can't even talk about. With social media, there has been a change. In years past, we never spoke about any animal that was taken in a seizure because it was usually still going through a criminal case. And now it's very common for people to fundraise.
And just to clarify, this does say further down on the page that if you request a forfeiture hearing pursuant to that subdivision, you then need to provide these funds security. But I'm just wondering if somebody is claiming financial hardship, they're not going to be charged those funds.
I think the intent of the law is that they would eventually be charged those funds. They're just not going to be required to pay.
At that point.
Yeah.
Thank you.
Sorry.
Yes. Two quick questions, then a shorter one. Do you have just ballpark this? How many organizations do we have in throughout the state of Vermont? Approximately, what are the costs involved statewide?
So there are 12 brick and mortar animal shelters that have been, in Vermont, helping local animals for decades. Santa Vermont Humane Society, we've been doing this for over 60 years. There are also a very large number of rescues that are usually foster-based. There's only a couple that have actual facilities. Many of them, their business plan is transporting animals from the south into Vermont. But post-pandemic, with the increases that we have seen because of the economy and housing and such, that there were so many animals being surrendered or abandoned, even some of those rescues are taking in animals and putting them into foster homes or trying to keep them somewhere with kennels to help our local law enforcement agencies. Ballparking how many cases there might be, it'd be very difficult to do because so many have been avoided. There's been nowhere for the animals to go. So a lot of law enforcement have been put in a really difficult position of seeing that there is animal cruelty happening in these locations where they're not being properly housed or cared for, but there's nowhere to take them, to seize them. And so in many cases, they've been left in those locations. So I think if we have better statutes to move these things along, we'll see an initial spike, and then we'll see that dropping off. Even initially, we're talking about, it's not like there's one courthouse that's going to handle all of these. So it would probably just be a couple or a few per court area per year And a hearing is probably a couple hours, depending on the evidence for the case.
So do these facilities take cats?
Yeah, well, yes, the brick and mortar shelters, the 12 that have fed humane societies, or just animal shelter, do have cats. Yes, the rescue organizations, it's very rare that any of them are working with cats, but some of them have been taking them in to try to help.
I was actually wondering, and I'm imagining that a neglected or animal cruelty case might be harder to foster. They may have challenging health stuff, challenging behavioral stuff. And so I'm wondering if you have any sense of how much harder, we're relying on fostering out because we don't have a lot of brick and mortar spaces.
Right. It's very difficult because these fosters for the rescues, these are folks who have volunteered and signed up to foster to basically take an animal off transport into their home, hopefully for a very short period of time before they're adopted out. Yes, the goal is that rescues are not bringing in behaviorally challenged animals and medically challenged animals. So these are often fosters who already have pets, and in many cases have children, and they just want to help. And this is a great way to, have an animal that they're not committing to at the time, or they may foster fail, as we call it. But to add an animal to that home that maybe has come from a really horrible situation that you don't even know what behavioral issues may arise until they've had a chance to settle. And so it is very risky to put them into foster homes.
Yeah, that's what I would have expected. Just they're social animals, and social animals respond to the circumstances around them. And
Absolutely.
as someone who has a dog and has fostered, I have to put the safety of my dog first.
Absolutely. And, some of these, as we're starting to see, like puppy mills spring up in the Northeast Kingdom. And so if you're getting animals for like the husky case where there were 55 huskies, very under socialized, by normal standards. So they may not do well with other animals. You're not, and they may be really under socialized with people and could potentially be a risk. Luckily, what we're seeing with these in the work that's being done with them by the ASPCA is that they are actually pretty well-balanced animals, but it's a surprise.
Yeah, well, I think Senator Ruth knows huskies can be challenging animals to begin with.
Well, yours is a category unto itself.
They're breeds.
Yes, they're special, but wonderful. So, it does create a problem. There is also, the issue that you have to look at, generally in a court case, there's, this is evidence, correct? So, depending on the circumstances, if the evidence lies in the location, lack of food, water, appropriate kennel size, that type of thing, then the animal might not be the evidence itself, right? You already gathered that evidence at that location. But if it's, an animal that has been starved or injured or that living being is your evidence. And so, you have got like a chain of custody behind this. You need to have proper care of that evidence as it's going through a court case. So just plopping them into a foster home is also a little risky in that regard. So.
Go ahead. Did you have another?
Yeah, are there enough foster homes?
No.
Okay.
So regarding the bill, one of the pieces that I wanted to dig a bit deeper on is on page 18, and a person claiming a legal interest is situations in which there could be a contested legal interest. So I know, unfortunately, sometimes in some relationships, when people are breaking up, somebody who's abusive may use the animal or use the pet as leverage, and may cause harm to the pet. And then I can see how that could lead to a forfeiture or a surrender. But then maybe the other person who previously cared for the pet and maybe paid some of the initial adoption fees wants to take the pet, And so I'm wondering if that's something that you've seen before, or yeah, do you have any thoughts on that issue?
Yeah, I mean, I can comment in a couple of ways about that. So we have seen, when you work in animal welfare, you're not just working with animals, right? You are working with people. The animals' problems are really a result of people problems. So we are often working through these situations, maybe not in a actual cruelty case, but we definitely get involved in situations, domestic families splitting up using, we've had animals surrendered to us when, one spouse was using them against the other. And we're going to work with the other person also to see if the animal go back into the best situation possible. Having in statute that if one of those people was committing animal cruelty, and then the statute does not allow them to possess animals for a certain amount of time, would be very beneficial, because if we say gave the animal back to the person that also has a claim on them, now the offender can't necessarily move in there, correct? So as relationships between humans are sometimes mended, that person would no longer, they would not be able to be there, the animal, and putting that animal at risk again. So having that kind of, probationary or post-offense restriction would be helpful in that case. But I don't think anybody is looking to ever separate animals from the people that love them and actually care for them properly. But I've often said to many people, love is not enough. You can love your animal fully and completely, and I understand that. But if you're not feeding them and caring for them and giving them medical care, that's not okay. So, if there's another party that was not involved in the offense and they have a legal claim to that animal also, I think that absolutely should be negotiated, but it's never black and white.
Yeah, I'm just thinking about the situation in which the person was abusing the animal, requests a forfeiture hearing, and then perhaps their ex or some other family member hears about what happened. I want to make sure that the pet doesn't go back to that person. I have a legal interest. I'm also going to make a claim. So I may work on some language just to clarify that in the event that it becomes a contested issue. But
and they could also testify then, could they had any information about why that animal should go back to that person. And they could participate in that.
And I think the other part is regarding the TAC order. I understand the rationale that, if you're actually taking care of the animal, you'll be going there at least once every 24 hours. I still think, though, that in order to make sure that there aren't going to be any loopholes or easy challenges, there still needs to be an additional, or rather a concurrent service of process where the humane officer or police officer is, right after nailing the order, they try to find the person and serve them in hand. And I think that really will just make it stronger in order to avoid a challenge saying, where somebody could say, I was hiring somebody else to go and they weren't going, and so therefore I didn't see the TAC order, or maybe a place that's conspicuous to the humane officer isn't actually conspicuous to the property owner or the pet owner or the livestock owner. So I guess that's just more of a comment, but yeah.
No, and I appreciate that. I really, that's why I said I appreciate the work you're all putting into this, figuring out the legal language and making it as tight as possible, because the last thing we want is to think that, we have all this great stuff in place and then there's another loophole for them to walk through. But also understand we're getting more and more cases of situations where animals are being abandoned in homes. That's another thing too. So, law enforcement or landlords, animal control officers are finding animals in apartments and homes. And so and that's a really hugely gray area right now. because they're not stray, they're inside the home. But they're not, so they're still that person's property, but if they abandon that property, and that is a violation of the statute. So could, an order be left there, but they're not coming back. So then how do you reach them? So we had some animals once for 3 or 4 months, going through the current civil forfeiture process with there never being a way to reach those folks. They had moved away. They didn't have any forwarding information. Nobody could find them. So we had to just go through the process of essentially they default by not appearing. And so that's something that one of those. And again, it's not just the burden this places on shelters who are less likely to aid, but it is the burden that places on these animals to live in an environment that is not really conducive to their best well-being for really long periods of time. We can get them into a good environment sooner.
Just one last question. So after describing a number of crimes, one of which is a felony if minors are involved, it says that livestock or poultry shall not be subject to forfeiture unless the person was convicted of abusing livestock or poultry. So they've abused their dog,
Yep.
but they also have cows or something. I'm a little of two minds about that. I think I understand that the idea is if this person is a farmer, let's say, and you take all of their livestock, you're taking their livelihood. On the other hand, there are some very serious sexual crimes that the person has been convicted of or charged with. So thoughts on that?
I think we have a very strong Department of Ag who works very hard on behalf of our agricultural community. And that there is a desire to keep that separate. And again, it's livelihood, as you mentioned. I would suggest that if somebody is committing those crimes with their dog, they are potentially probably also likely to do that with livestock. And so I would like to believe down the road that would then be dealt with. Again, that's just a huge generalization, but I think as Lisa testified, a lot of those crimes against animals, are found in the same dark web areas that the crimes against children are found, and that's why so much of this is really critical to the penalties on. And so I think when people are involved in those types of bestiality crimes, just crossing over, there's no difference in their line between a domesticated pet and a livestock animal.
Sure. Okay, thank you.
Thank you for coming in. I appreciate
You're
it.
welcome. And if as you're working through this, if you have any other questions, especially anything that you think members of the ACIMD could answer for you that I didn't, please let me know. Yeah, thank you for your hard work on this. I know you guys have a lot on your plate this year, but we appreciate that you give the animals attention too. Absolutely. Thank you. I'll let you know. So
You're welcome for the problem. We might look the same height.
Do you guys need the Zoom screen right?
Not unless the committee would find it helpful to have the ability to stop there.
I think so. We all have those on this. Yeah, we all have copies. We're still on 578. Yeah. All right, so we're going into markup on this bill. We got some suggested edits from my testified the other day. I'm somewhat, I had spent a lengthy amount of time going through the suggested edits, but after my first take, I'm a little unclear as to what sections are being referenced, because I see there's some underlines, but then there's other sections that are new that are underlined, but I'm not sure if where they match up with the actual subsections still, so I don't know if you folks at the time, if you were able to go through it and see what's new versus what's old.
We were.
Oh, yeah. Thank you. So, well, I guess I'll turn it over to you guys, if you want to share your initial, any of the differences that you could highlight for us and what the proposals are.
Happy to. Great. Eric Fitzpatrick with the Office of Legislative Counsel.
And Hillary Chutter Ames, for the Office of Legislative Counsel.
And we're both here this morning, just so the committee knows that the topic in our judiciary team portfolio of animal cruelty, animal welfare, is generally in the topic of the attorney position that Hillary fills. I was starting it this year because Hillary was onboarding in January, but now that she's further along in the session, we're going to be transitioning this to Hillary's portfolio. So that's why we're both here now. So in the future, which might even be tomorrow, depending on when you next look at this, it might be that you just see Hillary and myself. But we've both been looking at this over the last couple of days, and I think we can both chip in as far as the markup goes this morning. That's good?
Yeah.
All right. Excellent. So that being said, there wasn't anything in, so I was taking some notes as well during the last time we was talking about this, about potential areas that you might have some ideas about possible amendments. Senator Shim, you just mentioned some, for example, when you were speaking with the previous witness. I jotted those down. And as well, we have, as you mentioned, some suggestions from Lisa as well, the Director of Animal Welfare. So we can start with those. But just so the committee knows, I don't have anything, I didn't catch any changes the committee was really thinking about until the forfeiture process on page 14. So if I'm missing something, let me know, or, you know, if any committee member sees anything before that, that was the stuff about sexual conduct with the animal and making that particularly with respect to video images, making clear that that's part of the misdemeanor crime, making it a felony when it involves a minor. I didn't hear any changes about that. All the other provisions related to forfeiture of an animal in the future, you know, the other possible consequences that could be imposed by a court. That's the second piece of proposed second issue that's addressed in H578 about, you know, expanding it to be when an animal resides with, down south, that sort of thing. So I'll turn it back to the committee, but I didn't catch anything, but please correct me.
Senator Host.
So one of the things I raised, and I know it is underlying statute, is whether or not we think that sexual contact with an animal should ever be just a misdemeanor.
Right.
You know, as I sort of, I don't know, kind of vaguely can understand the concept of a child is involved, but I feel like there's, yeah, I just have some questions about like whether or not we feel like the underlying law makes sense, I guess.
Mhm.
And like I said, I do know it is current law.
Sure.
And they're different, but I was talking earlier and asked the question about your going through the process for having abused your dog.
Yeah.
But it specifically protects your right to have any other kind of livestock, unless you're accused of abusing that particular kind of livestock. I think I have the same kind of question there. In both cases, it's like we're treating the incident that's not as serious as it could have been, rather than.
Because of who or what is involved.
Right. And, you know, to what the witness said about the Department of Ag, I took that to be an allusion to, you know, having done my time on the Agriculture Committee, I know that there are always attempts to balance the rights of farmers, almost sovereign rights of farmers, against whatever regulatory scheme is being proposed. So I'm assuming that this represents an attempt to compromise as it decreases the amount of time, raises the amount of money that somebody convicted has, but it also protects their likelihood maybe as a farmer. So I share what you're saying. I don't know if there's a.
Well, can I circle back to, and I'm just, animals don't have the capacity to consent, much like children. And I don't think we ever treat sexual abuse of a child as a misdemeanor.
Are we talking about the markup from Lisa Mylod or?
No, just generally.
Okay, so let's do the markup and the suggestions from Lisa Mylod first, and then you can circle back around to other suggestions that we may have, if that works.
Whatever you got. Perfect. Okay. That's the only other, but before we just transition to that, just to sort of close that little loop on that discussion, another parallel between the two issues that were being mentioned by Senator Hutchins and Senator Group is that also the livestock and poultry section, just so you know, is also existing law. It wasn't something that was created this year. It was
Because it's in here twice underlined.
yes, but it's done, it's rephrased because it wasn't really clear. But it is like in both places except livestock and poultry. It's existing law as well.
That's good.
Not to say that all the question is totally up to you. All right, so having said that, then let's move to the forfeiture section of the bill, which is also the only place that the proposed amendments were made by Lisa and the email that everybody received, and that begins at least is everybody looking at the as passed by House version?
Yes.
Without underlines
Yes.
or strikeouts.
Yes, exactly. So that begins, this section that we're talking about, the forfeiture starts on page 14, section 5. So the first issue we'll talk about then, and you'll see you have already talked about it in subsection A on page 14, lines 12 and 13. This is the general provision that requires that before one of these enforcement actions begins, there has to be a consultation with the Secretary of Agriculture. And then there was a Vermont Supreme Court case that said, hey, that even though it says shall in line 7, that the failure to do that doesn't mean that the enforcement action has to be dismissed. So that sentence you see underlined on lines 12 and 13 is a putting in statute and put the current laws from the Vermont Supreme Court case. Now that was done in the House. That's in the bill. It's passed by the House. The reason I'm highlighting that is because if you want to, this is if you're mentioning Senator Sheen, well, where are the proposals in the Director of Animal Welfare's proposal? Where did it? Some of them are right here in this section. And for example, one is, and actually before I get this, let's look for a second, because there's another place that the same concept is addressed. We'll go around page 50. Lines 9 to 12. This is the piece where a humane officer, under current law, line 9, that struck through word must, under current law, a veterinarian licensed to practice in Vermont, must accompany a humane officer during the execution of the warrant. So in other words, when they're going out there seizing the animal, right? Again, there as well, similar sentence was added, the very last sentence. They are to be accompanied by the vet. Doesn't mean that the enforcement action has to be dismissed. However, notice the difference, and this is something I just noticed, and this is our general recommendation here is going to be consistent. Whatever you decide, it's a policy call for you guys. But, and we noticed this, I should have caught this in the House, that on line 9, it changes the must to shall if practicable. Whereas if we went back to the place we just looked at, the Secretary of Agriculture, page 14, line 7, it says shall, and then if practicable wasn't added. Pretty likely a court would look at that and be like, the legislature amended this bill and they added it's practicable right here, but they chose not to add it there. That must mean something, even if the only real reason was that I didn't notice it. So whatever you choose, be practical. I mean, be consistent. So if you want to add if practicable here, good idea to add it on line 7 as well, or don't add it in both places, whichever you prefer.
Is there anybody opposed to adding if practicable to line 7 on page 14?
That seems to make it make more sense and not be quite as contradictory. So I would certainly support that.
And now I just would also point out that in Lisa's email, she was suggesting changing the shall to should. Our personal preferences don't generally use should. Shall, if practicable, is something that's not unusual. It's the same idea, same result.
It should, just seems like you're admonishing.
Right.
You know,
And when should you not?
That's a very loaded word.
Right.
And that's part of the challenge with these first three of the suggestions from Lisa, is each of the requirements that they're pertaining to say shall consult the Secretary of Agriculture, shall bring a surrendered animal to a vet, or shall bring a vet with you to seize the animal. But courts have found in all those cases that those requirements are intended to protect animal welfare, not protect the defendant's rights or the owner's rights to the animal. So I think for these first three suggestions from Lisa, they're trying to implement some of what these courts have concluded, that failing to consult the secretary, failing to bring an animal within 72 hours to a vet who's been voluntarily surrendered, or failing to bring a licensed Vermont vet with you to seize an animal, the proper remedy isn't to dismiss the enforcement action, or, exclude evidence seized when you're executing a warrant. The answer is this is guidance for the humane officer, and not something that a defendant can raise to try to challenge the evidence or get the enforcement action dismissed. So I think all of these edits are trying to capture that. I think one thought we had besides consistency, and we can point out a couple other places where it might be worth being consistent. So on page 14, the suggestion from Lisa is to add, this would be on line 9, page 14, line 9, after that first sentence. So on line 9, after livestock or poultry, the suggestion is to add, if needed to determine, or at the end of that sentence, to add, essentially consult the secretary if needed to determine whether animal husbandry standards were violated, which later in this subsection, that's why the secretary, or that's what the secretary will do if consulted. Here it's if needed or if necessary, but the similar change that Lisa's suggesting in the next two subdivisions for voluntary surrender, bringing it to a vet, or bringing a vet with you to seize the animal. The suggested language is if believed to be necessary. And so I think one choice for the committee is, if it's based on a belief that it's necessary, useful to specify who, likely the humane officer here. And we recommend that in each of these three sections that either can be objective if necessary to do what is specified, or in all three scenarios, the subjective version, if the humane officer believes it's necessary. So choice for you, I think. Practical results, not necessarily clear.
I'm a little confused about where the suggestion is to change the language. Is it, let's just take paragraph A.
Yep.
What is the suggested change then?
So on line 9, at the end of this first sentence, it would add, if needed to determine whether animal husbandry standards were violated.
Law enforcement.
No, period.
Period. Period.
So the idea would be like that first sentence now says the secretary shall be consulted prior to any enforcement action. Right, but it's Hillary saying the proposed modification is if needed to determine whether animal husbandry standards were violated. In other words, it's a qualification on the consultation. You don't have to always consult, which in a way we sort of feel also already addressed by adding the if practicable language, and the failure to consult isn't grounds for dismissal. So there is sort of a requirement. Whether
How many times and ways do you want to say?
Right.
It's not a strict consultation requirement.
My initial reaction is to not leave it to the discretion of the police officer, the humane officer. I think that it should be a standardized practice where you consult to make that determination. But that's my initial take on it. Senator Holston.
I'm just trying to understand, so the way this is worded now, would this apply only to agriculture cases, or would it apply to any time someone shows up to a law enforcement officer shows up to an animal cruelty or neglect? Because it seems to me that it would be immediately able to be deemed not necessary if they were showing up to deal with a dog as opposed to a cow.
Yeah, so on lines 8 through 9, it's any enforcement action that involves livestock or poultry. So already, we're narrow of cases. I think if they showed up for a dog, but there were livestock or poultry on the property, maybe there's a consultation requirement. But I think the whole way this is structured is that the humane officer shall consult, but the penalty for not consulting is not that the enforcement action is dismissed.
Okay. That sort of makes sense. This thought, because I think you said that the same suggestion. So later in the bill, they talk about consulting with a veterinarian.
Yes.
And what some of the testimony we heard is those veterinarians often aren't available, and the humane officers may be able to. So I wonder if the real thing piece there is a veterinarian or humane officer could be the consultation to determine if medical care is necessary. Okay. You looked confused, so I wasn't sure.
But I think the humane officer is already
Okay.
going to be participating in the execution of the warrant. I think, right? Is that what you're thinking of? Subdivision 2, page 15.
Thank you. I was trying to reorient myself to the bill.
Yes.
Well, it's,
But maybe you're thinking of, but that one also was,
well, it says a
The veterinarian.
veterinarian license
Yes.
to practice. So what I'm suggesting is it may need to be reworded, a veterinarian or humane office license to practice, or a humane officer shall if practical, because it broadens the window of people that may be qualified to help deem what that animal needs. And we heard from Lisa that the veterinarians often are not available.
right.
One way to do that is as amended by the House, you have the veterinarian shall, if practical, accompany the humane officer. But the default, if it's not practicable,
Okay.
is it will be the humane officer.
Because it's the humane officer
That is
executing the warrant.
executing the warrant and
Right.
doing the search and seizure.
So it's not law enforcement.
Well, a humane
So
officer.
confused.
No, humane officer includes law enforcement, but isn't necessary. It could be the local animal control officer, just that's the way but it might be a law enforcement officer. So maybe, I don't know, you haven't consulted with a local animal control officer, because maybe does a law enforcement officer, does humane officer require particularized training?
Yes.
Okay.
I don't know if I can speak out, but the ACIB was a big part of changing the definition of humane officer. So it used to include like Humane Society employees and such. It's a very narrow definition now, and it's law enforcement, and it's the few animal control officers that are employed by law enforcement agencies. So animal control officers are not considered humane officers, and they are not all trained in animal cruelty investigations. So you do need to be careful about adding animal control officers anywhere in there as being qualified.
Correct. No, I was suggesting the humane officer, but that's actually really helpful. I think part of my confusion was that definition is not in front of me.
Right.
So let's carry on.
So I think are there any other questions on that piece? The next question that I had was regarding this exclusion of evidence piece, and I think you folks were alluding to that earlier. Can we talk a bit more about that?
So this is coming from several of the cases that Lisa had shared, and what these first 3 edits are based on are cases where there was an enforcement action, and for example, the humane officer executing the warrant did not bring a vet with them when they executed the warrant. The defendant argued you should throw out all of the evidence that the humane officer obtained while executing the warrant because they didn't satisfy the statutory requirement to bring a vet. And the court said the legislature didn't specify that suppression of evidence is a remedy for failing to bring a vet with you when you execute the warrant. And we think based on reading the statute, they didn't want that to happen. So they, denied the request to suppress evidence, including that along with dismissal of the enforcement action in these three spots is specifying that when the legislature is requiring that you bring a vet, that you consult, there's no intention that the proper remedy for failing to do that is dismissing the action or suppressing evidence obtained while executing the warrant.
So then this might be a question for Lisa, but, and maybe I'm missing something, but if the motion to suppress was denied, why would it be necessary to include this new line of excluding evidence?
I think the idea is there can be value sometimes in specifying in a statute something that the legislature thinks a court has correctly held in interpreting a statute. So it's providing further clarity in a statute. I think it's a fair point that someone running into that argument again would read that case and say, exclusion of evidence isn't a proper remedy, and avoid that outcome. But amending the statute to be clear about that could be useful for practitioners. It also might be needed if you add other language about the consultation, because the interpretation of the statute and whether you implied that you intend there to be a certain remedy can change depending on how much of what you say about the requirement.
I think so next question would be, you know, in situations where perhaps there is evidence that should be suppressed, whether it's because they've been lacking probable cause or there was an unlawful search. You know, kind of worried about the blanket statement of excluding potentially all evidence.
So the way it's crafted, I think it's an important concern to avoid. The way it's crafted is narrow. So failure to conduct the consultation shall not be grounds for exclusion of evidence. You exclude an evidence on a certain basis, right? So if there is a lack of probable cause, that would be a different ground or basis on which to exclude the evidence. And we can, you know, take a second look and just make sure we feel really comfortable about how narrowly that's crafted. But as drafted, it is specifying that the only ground on which you should not exclude evidence is the failure to conduct the consultation.
Yeah, that clarifies. Thank you.
In case anyone was wondering, where it would go, page 14, line 13. And there'd be parallel language in each of these three paragraphs, but this gives you a good example. So the sentence would read, failure to conduct the consultation should not be grounds for dismissal of the enforcement action or exclusion of evidence. So that's the concept, right?
Yeah, I'm good with adding that. I still have to read over those cases, but I don't, and the explanations were helpful, so I don't see at the moment any issues. So at the moment, I'm good with adding it, but maybe are there any other thoughts on that?
In reference to what
The exclusion.
challenge, I'm looking at the public cause, that you have to probably establish public cause by issuing the warrant. And then what the chair referred to is the attorney challenging the validity of the probable cause in court, which is a separate area in itself. So I'm good with that.
The recommendation we make, just like putting shall if practicable in these three areas for consistency, is there would now be three areas where the provision would end with failure to conduct the consultation or failure to complete the requirement. I'll point out these three areas shall not be grounds for dismissal of the enforcement action for exclusion of evidence. So the first place that would go is subsection A. This is page 14, lines 12 through 13. The second place that a similar sentence would go would be in subdivision B1 at the bottom of page 14. This would come at the end of the sentence on line 21. So it would mean adding after the end of the sentence on line 21, and this is a suggestion from Lisa, failure to have the animal examined and assessed within 72 hours shall not be grounds for dismissal of the enforcement action or exclusion of evidence. So as Eric mentioned, a court reading through this section of the statute is going to say, they're going to note if language is included somewhere in a similar section and excluded elsewhere. And they're going to find some kind of meaning in that. So the suggestion is to be consistent.
I have a little bit of concern with that prohibiting the dismissal of the enforcement action, because can somebody could voluntarily surrender an animal that could theoretically be in good health, and then they're not examined over the course of 72 hours. And while they are kept in, whatever kennel or barn, after a week or two, they degrade for some reason, because they're isolated or for whatever reason. And then they get examined, let's say a week later, and they're in, poorer health. So I worry about that completely shutting out the possibility to dismiss an action if it's. Do you get where I'm coming from?
Yes, we had that same discussion. I raised the same question, which was like, is the voluntary surrender situation kind of different? Like maybe you don't want that language here. I don't have an answer. I'm not an expert in it. I had the same question. I'm not sure. I had the same question about like line 20. Do we want to say impracticable there in the voluntary situation? Because maybe in that situation, kind of the opposite circumstance. Someone brings in an animal voluntarily that's in very bad shape. Do you still want that? Maybe you do want that. In that situation, maybe you want them to have to be examined quickly, although maybe 72 hours isn't always possible. So you have to have it practical. I don't know. But anyway, we had the same kinds of questions. So maybe you want to ask your witnesses that, whether it makes sense to have it there also.
Yeah, so put a little star next to that and come back to it, but okay, thank you.
So I think the other place to consider it is this is page 15, subdivision B2. On lines 10 through 12, there's already been added failure to be accompanied by a veterinarian during the execution of the search warrant shall not be grounds for dismissal of the enforcement action. That's in the version amended by the House, passed by the House. And Lisa's suggestion is to add at the end of that sentence on line 12, or exclusion of evidence. So unless, as you flagged for the voluntary surrender, there might be a good reason to provide differently here, unless there's a good reason to think that exclusion of evidence should be treated differently for this requirement. Lisa's suggesting to add or exclusion of evidence to the act.
That makes sense to me, based on your description of the court's thinking of whether something's with the animal's welfare or welfare of the welfare of due process afforded them.
So the question is, are we adding exclusion of evidence to line 12? Right. I'm good with that. But now I don't see any reason, based on what I've learned so far, to not have that. So, honestly, maybe feel good.
So there's one other aspect of, we're still on these kind of first three changes suggested by Lisa, and these same three provisions that we've been talking about on pages 14 and 15. There's one other kind of change that Lisa's edits suggest in each of these sections. And we've already talked about one of them, but it's essentially right after the statute says that the humane officer shall do something. It's adding kind of the circumstances under which that's important. So kind of describing, you shall do it if these facts are present. So the first one is that we've already kind of discussed, but maybe didn't land on. Page 14, line 9. Before the end of this sentence, so the sentence reads, the Secretary of Agriculture shall be consulted prior to any enforcement action that involves livestock or poultry if, and this is the suggestion that Lisa would add, if needed to determine whether animal husbandry standards were violated. So that's a way of, it's still not saying that failing to consult has a particular remedy, but it's adding more language about when law enforcement or humane officer should consult with Secretary of Agriculture.
And where is this being proposed on page 15?
It's on page 14, line 9. It would come right after page 3.
But there is parallel language proposed for page 15. The parallel language is proposed in all three of those subjects. Some sort of qualifier on the requirement that a consultation should be made or the veterinarian company, that sort of thing. Some qualifier based on whether or not, as Cody was saying, the first instance, whether it's needed to determine whether animal husbandry standards are violated. And the last one is whether the accompaniment is necessary to stabilize the condition and provide immediate treatment of the animal. So it's whether or not you want to be a little more specific about that, or just keep it impracticable along with the kind of related, if you don't do it, it doesn't get excluded or dismissed.
Yeah, I thought, so I mean, I remember that my initial take was to kind of put a pin in the idea of if needed to determine if standards were violated. I think that there should be a consultation with the Secretary of Ag, whether or not law enforcement thinks there needs to be one. I think the Agency of Ag has a better understanding of the protocols and everything, so it's best for them to make that determination, in my opinion.
I generally agree. I think all things being equal, we want that consultation. But this sentence strikes me as more, if on the one hand, we're talking about what's for the welfare of the animal and what's, due process for it. This seems like it goes in the middle because it's required, it's a shall. And if we add, if we don't add anything, it seems to me somebody could argue that it should be thrown out because nobody consulted with the secretary about traditional practices or whatever. So it seems to me it does need qualification, and I don't have a choice about whether if practicable or the suggested language is the way to qualify it, but
I think if practicable makes sense. I mean, there are certainly common sense things that an officer can observe and, make a determination, but, there may be situations where it's unclear to the officer and maybe they have more time and, they can correspond with the Agency of Ag to clarify questions that they may have. But I think, if practicable, that covers the scenarios where there may not be the time necessary to contact the Agency of Ag. So I'm good with it practical for now. Then, if maybe want to change anything else, then we can discuss that later on.
Does it imply, according to normal practice, if you say the secretary, that a deputy couldn't, in their absence, would?
Yes, they could. It doesn't have to be that individual.
Okay.
Generally speaking, normal practice means, I know it doesn't say or designate, but that's generally the way I thought that would refer to names here. Yeah. And then you have, because of that final sentence, it wouldn't be thrown out, even if they don't do it. That's saying, the failure to do it is a ground for dismissal. So that's made clear in the final sentence. It's a that case. Right.
All right, so that's an answer for this subsection A. A similar suggestion, this is making a similar suggestion in subdivision B1. So this is, this would be page 14 at the end of line 21. The sentence that right now is on lines 20 to 21 would read, the humane officer shall, you've added it, practicable, have a surrendered animal examined and assessed within 72 hours by a veterinarian licensed to practice in the state of Vermont. If believed necessary, and this is what we would add, if believed necessary to stabilize the condition of or provide treatment to the animal. So same question, you know, if practicable is qualifying shall already. Is this further detailed? Does anybody want to stick with if practicable or add this kind of further detail about when the humane officer should be
In
bringing up surrendered animal to a vet?
my opinion, for the voluntary surrender, the animal should be examined and assessed within 72 hours. Period. That's my opinion, but maybe you have any thoughts?
Yeah, just one. I agree that the animal should be examined, but if practical is added in there, I take voluntary surrender at 6 o'clock at night on Friday night, and Monday happens to be a holiday. Nobody's broken the law here. But I get that animal within 72 hours. It could happen, that's all I'm saying.
One other option is here, the requirement is both bring to vet and do it within 72 hours. And if your point, Senator Sheen, is you definitely want it to be bring to vet, but you want some flexibility about the 72 hours,
Right.
you could have it read the humane officer shall have a surrendered animal examined and assessed within 72 hours, comma, or as soon as reasonably practical, comma, or something like that, which would give the flexibility of the time frame, but not suggest that the animal should not be brought to a vet.
Yeah. I think that makes sense. Senator Poston.
That does make sense to me. I also am, and I just don't know the answer to this, like from my Chittenden County context, we have multiple emergency vets. I can get my dog seen within 72 hours, even if it's Christmas. But I don't know if that's true. Okay.
Someone who's not living in Chittenden County,
That is not true. Okay.
Yeah.
I think if reasonably practicable.
As soon as,
Yeah.
as soon as reasonably practicable. Okay.
Any other thoughts on that?
I think we're basically at versions of the same language.
In all three paragraphs. Yes. It's just.
But I do appreciate your point that that is more about the time frame and less about whether or not it needs to be done.
And it addresses, I think, the point you were making earlier that having it done as soon as possible is important so that if there is some deterioration in the health of the animal, that can be addressed. So I think to round out the suggested edits in these first three sections, the last one is page 15. We're back in subdivision B2. And the suggested edit would be at the end of the sentence that runs from line 8 through line 10. So a veterinarian licensed to practice in Vermont shall, if practicable, accompany the humane officer during the execution of the search warrant. And before the end of this sentence, Lisa's suggested edit would add, if believed necessary to stabilize the condition of or provide immediate treatment to an animal being seized. So again, this is kind of adding some qualifying language about why and when you should bring the vet. And this might be a circumstance where I think, again, you could leave it as if practicable, and failure to do it doesn't mean you dismiss the action or exclude evidence. Or you could add some qualifying language like what Lisa suggested.
If we add the qualifying language and still keep if practicable, that seems like a lot of qualification for a shall. Seems like at that point you should just rethink having the shall requirements for the event. That's all.
Yeah, I think having if practicable and the if believed necessary could create some countervailing recommendations.
I'm fine with the language as it appears, that's past house. Because we are adding flexibility and we're also saying that if that isn't there for any reason, it doesn't mean it gets dismissed, so. It seems like the flexibility that she's looking for is already there without needing any additional scenarios which must have the evidence.
And I think you could ask these other witnesses if there's a particular, if they see a particular value in adding the kind of qualifier she is suggesting.
Because let's say that further,
Right.
let's say that there's a general shortage of vets and they just can't find a vet under this language, that would be fine. So. I don't know, it seems like 6 of 1 happens.
That's 6.
I was, I hear Senator Bruce's point, and if they can't find a vet, I wouldn't want it to hold them up in taking the animals from a dangerous, unhealthy, or cruel situation. And I know, I don't think we heard it in this committee, but we have the other animal cruelty bill in my other committee. And what we've heard is that there is a massive shortage of vets in most of the state. And so if someone's called every vet in the county and none of them are available, I wouldn't want them to not be able to seize those animals.
Yeah, I'm open-minded, just keep, if practicable, and then add or exclusion of evidence. The end of line 12, consistent with how we have it in other sections as well. But yeah, I think if practicable is sufficient for this. Any other thoughts, committee, on that section? Anybody opposed?
No, I like the consistency with the other sections.
All right, and perhaps a more roundabout way than I could have done, but I think that runs us through the edits, the first 3 of these edits to these 3 sections. So I think we could move to page 18 and kind of the next bucket of suggested edits that have to do with sort of the notice. So I guess we could go ahead and read what so this is on page 18, lines 5 through 11.
I'd be helpful for a moment to give a minute or two of what we're talking about here, though.
Perfect, I'll give you that.
Actually, so bottom of 17, just sort of, so we're now in the forfeiture piece, right? We've just been talking about procedures prior to the actual forfeiture of the animal. Let's say the animal does get forfeited or by a humane officer. Bottom of page 17. What happens then? Well, unless the person claiming a legal interest, and there's that phrase, Sarah, that you were concerned about legal interest, and just to note there real quickly, Hillary and I spoke about this, looked at the existing statute. Ownership interest would be a better way to phrase that, because then you're talking about co-owner situations. So a bit of ambiguity with legal interest. What does that mean? Who does that cover? But sometimes animals do have co-owners, and in that case, the existing law does preserve the right of. I know sometimes it creates difficult situations, as the committee was talking about earlier. For example, there's a family law situation involving divorce or whatever it might be. There are any number of situations where that could cause problems, but that is the existing law. You know, animal has more than one owner, could be returned to one owner if the other one is the one who's charged with the cruelty violation. So if you're to keep that, I think our suggestion was wherever it appears, change legal to owner. Ownership. Yeah, right.
I'm fine with that. Unless committee, is there any other?
All right, so that point aside for a second. So the person, unless a person claiming an ownership interest in the animal requests a forfeiture hearing and post security over in the top page 18 now, or requests that the security be reduced or waived on the basis of hardship, then title is forfeited 14 days after seizure. So if you think about how that works, animal control officer comes to the place where the animal is, they seize the animal, 14-day clock starts ticking. At that moment, they give notice to the owner, if the owner's there, hey, here's notice of your rights. You can ask for a hearing if you want. You can request financial hardship, because if you don't, you got to start paying security soon. And that way, they are apprised of their rights. They have this is the constitutional requirement here. Someone's property is being seized by the government. Yes.
What does that consist of, postal security? What is that amount? Or what is that?
That's going to be, you mean, like, what's the amount,
Yeah.
actually? That's going to be elsewhere in the bill. The
Okay.
Director of Animal Welfare has to, by rule, issue amounts and payments, periodic payments, schedule. Thank you. Payments.
Vary on animal or?
Yes, that's the idea. Exactly. It's going to be different depending on the type of animal. So that amount eventually, hopefully, will be in this notice that the person gets, if they're there. If they're not there, that's when the tagging comes into play, right? Although that's a question for the committee, if you want to be tagged, whether they're there or not. Policy question.
Lisa Myla made a suggestion about the sort of nail and nail system,
Right.
which I think it seems to make me, it does not seem to make me, I know how I feel, it makes me more comfortable. But I also have the question of sort of what would be, I mean, I'm just thinking of some of these circumstances. I go to a field to, well, I mean, I know, 'cause I'm not a main officer, but I go, someone goes to a field to rescue horses and what do you tack it to? There's no building, so there's that piece, but I did have more security around the sort of tack and nail scheme.
Yeah, what I'm seeing in her recommendation is the 96 hours, they nail it, and then over the course of 96 hours, what is that, 4 days? They have to make attempts of service. I'm wondering if there should be at least one attempt to serve the person in person prior to doing the tag order. Yeah, I know with, when you make a motion for alternative service, you have to at least have made an attempt to serve the person, or you're aware that it's impracticable. So I don't know. I mean, there's so many different circumstances where, maybe prior to getting the warrant, you've tried locating the person, so I guess I don't know where I'm going with this, but is there a way to require an attempt of service, and then if you realize we're just in a field in the middle of the woods, we don't know where to go, we've got to tack it on something and then make subsequent attempts? Is that doable?
I think you're likely to have a fence if you are seizing animals somewhere that someone has domestically. Could be a place for tacking in a field, but fair point that there could be a scenario where tacking would be physically challenging. You can certainly draft requirements that the humane officer attempt service in person before they can resort to tacking. I think one challenge I see practically potentially with that is humane officer gets their warrant. They show up at the home thinking someone could be home. It's not an abandoned house, but the person is not there. There is no person there. So they can't effectuate personal service. If they are required to try to effectuate personal service before tacking, it means they're leaving the home and spending some time trying to effectuate service. And then they'd have to come back again to tack. That's not, that's certainly a possible requirement. It just would take more time than what the original kind of tack provision would allow, because they're leaving before they can come back. So as long as everyone's thinking about that.
But just their presence knocking on the door, holding papers in hand, isn't that an attempt? And then they can back and go
at which-
to the door.
That's two.
That's two,
Yeah, I wouldn't want to add another layer to it. I agree with Senator Polowski that nail and nail, or whatever you call it, would maybe it's more than what exists currently, and it seems to me maybe you can't get a hold of somebody by email. Maybe the tag doesn't work, but having both of them fail seems almost very unlikely to me. And that does seem like a good faith attempt to effectuate services.
Yeah, I'm fine with that. I think, I mean, as long as it is reasonably evaluated to inform the owner of service and seizure, then I think we'd be on safe ground with the nail and nail idea.
Okay, so detective personal service wants, when they show up there. So they're out there, so they nail it and they nail it. So I think you're right, you know, there's a good argument there that that's reasonably calculated under the circumstances to provide notice.
So we do have Maria on the Zoom for the next bill, so we'll take Senator Mattis's question and then just a 2-minute break and then we'll come back. Probably, we'll definitely have to revisit this.
Yeah, I was just gonna say, it kind of reminds me of the landlord bill that we were working on. So that, I think it makes sense that we assume after, 5 days, that it was received in the mail and back in on the door or fence, whatever it is.
And they show up and they're 3 hours, they're gone, they're gonna call for 20 days, so.
I bet you if there's something now at the post.
Yeah.
All right, so thank you, and we'll revisit this at a later date, make the decision. So yeah, thank you. And we'll let Maria know, we'll take a 2 or 3 minute break and then we'll come back and get started.
Okay, so you like to go outside.
Yeah. We'll move to something.